Good afternoon, everyone. Welcome to the second in the series of the Rural Dispute webinars, which the Rural Dispute Resolution team at Shepherd and Wedderburn are hosting. My name's Hamish Lean. I'm the head of the Rural Property and Business team at Shepherd and Wedderburn, and my particular interest is in relation to agricultural tenancies, particularly when they become contentious. The subject of today's webinar is succession to agricultural tenancies, the rules, time limits, objections, problems and pitfalls. This is something of a mystery to many people, and I hope that as a result of today's webinar you'll have a clearer understanding of the law that applies, the time limits that you need to watch out for, and some of the traps which the unwary can fall into. It's not going to be a black letter law webinar in which I'm quoting lots of statutes and sections and cases at you. It'll be a fairly broad level discussion. There is an opportunity to submit questions online, and if anybody is interested enough to ask a question, I'll do my best to answer it at the end of the webinar. Likewise, if anybody would like to get in touch direct with me afterwards with a query or perhaps an actual real life problem, please feel free to do so. So, what I'm going to look at today are the different routes to succession, how you identify which route to follow, the time limits that are applicable in relation to each route, how you go about making an objection, what you do if you're on the receiving end of an objection, and what part does the Land Court play in all of that. Now, the good news, the Land Reform Scotland Act 2016 introduced a uniform set of succession rules applicable to all forms of agricultural tenancy. The rules apply to all deaths taking place after the 23rd of December 2017. In practice, because of the time limits involved, every succession which you're likely to deal with now will be dealt with under the uniform rules introduced by the 2016 Act. So those rules apply to secure tenancies under the Agricultural Holdings Scotland Act 1991 and also to all forms of fixed duration tenancy under the Agricultural Holdings Scotland Act 2003, regardless of whether they're short limited duration tenancies, limited duration tenancies, modern limited duration tenancies or repairing tenancies when the latter are introduced in due course. So thinking about the way in which an agricultural tenancy can be inherited, there are two routes to succession: testate succession and intestate succession. So, put very simply, testate succession is the way that we describe succession because of a formal bequest in the deceased person's will. I leave my interest as tenant of Auchenshugal Farm to my daughter Shona, for example. That's a bequest. Intestate succession is transferred by the deceased's executors as an item of intestate estate, i.e. an item of an estate which hasn't been provided for in the deceased's will. Now, the first question to ask so far as testate succession is concerned is whether or not the lease actually allows the tenant to make a formal bequest of their interest in the tenancy. Most written leases will actually contain a prohibition against the tenant doing that, and a simple prohibition against assignation will be sufficient to disallow the tenant from leaving their interest as tenant in their will. What happens then is that the lease is then treated as an item of intestate estate and will therefore be available for transfer by the deceased's executors. And I'll be looking at the procedure by which that happens in more detail in due course. But sticking with testate transfer in the meantime. And before I go into detail about that, the other thing to notice about this is that different time limits apply to testate succession and intestate succession. And I'll have something to say about what those time limits are later in the presentation. So, looking now closely at testate succession, presuming that the lease is a lease which allows the tenant to make a formal bequest of their interest in the tenancy, and actually at the end of the day that's only ever likely to be a lease in which there is nothing regulating the tenancy in writing. So that is a classic scenario, for example, where a grazing tenant has overstayed their welcome and an agricultural tenancy, whether secure or limited duration, has been created by operation of law. In any event, where it is possible to make a bequest of the tenancy, the range of persons to whom the tenant is entitled to bequeath the tenancy are as set out in the slide. I'm not going to bother to read those through because it would be quite tedious, I think. But you'll see as I go through the slides that the range of potential persons to whom the tenant can bequeath the tenancy is really quite wide indeed. And in fact, as you can see from the slides, that there are 14 separate categories of really quite remote family members who might receive a tenancy by bequest. However, the law also defines a more restricted category of relation, whom the 2016 Act define as near relatives, and they are a category of much closer family members. And once again, I've set those out on the slides. I'm not going to bother to read through them, but I'll just work my way through the slides on the screen, and you can see the people who fall within the definition of near relative. And you can see that those near relatives are in a much closer family relation to the deceased tenant than the much wider category which appeared on the previous slides. So why have this distinction at all between near relatives and that wider category of relative? And the reason is to do with the grounds upon which the landlord is entitled to object to someone becoming the tenant. Where the person inheriting the tenancy is a near relative, the landlord's rights of objection are limited to 3 grounds. Firstly, that the person inheriting the tenancy is not of good character. What do we mean by that? An alcoholic might not be a suitable person to obtain the tenancy. Someone who has been convicted of a serious criminal offence, or perhaps a serious offence of dishonesty, would not be a person of good character. Second ground of objection is that the person inheriting the tenancy does not have the financial resources that would allow them to farm the holding that has been inherited efficiently and to pay the rent. The third category of objection is that the person doesn't have the necessary skills and experience in order to farm the holding in accordance with the rules of good husbandry. However, there is a get out of jail card, which is that even if the person inheriting has no skills and experience whatsoever, as long as they sign up to a suitable course in agriculture within 6 months of becoming the tenant, that will provide them with the necessary skills and experience, and that they're expected to complete the course within 4 years, and they make satisfactory arrangements for the farm to be looked after in their absence, the skills and experience objection will not be sustained. So if you're a near relative, an objection will only be sustained if it can fall within one of those three categories. On the skills and experience point as well, skills and experience can be demonstrated by practical skill and experience acquired over a large number of years. For example, a son or daughter who has been in partnership for many years with their parent who has actually been the tenant might well be able to demonstrate that they have the skills and experience to be able to run the farm without having a paper qualification to their name. However, where the successor is not a near relative, it's for the person who is inheriting the tenancy to persuade the land court that there is a reasonable ground that they become the tenant. Now, it's important to note that the landlord's own wishes and plans for the future of the farm have no part to play in this test. So the landlord isn't able to object to a succession on the basis that they have some sort of long-term plan to take the farm back in hand and so on. If they wish to challenge the tenancy along those lines, they would have to look at one of the grounds for serving a notice to quit, which might have to do with the landlord's own intentions. But it will not form the basis of an objection at this stage where a tenancy is being inherited. So reasonableness revolves around what is reasonable for the inheriting tenant. And the onus is on the tenant who is inheriting to persuade the land court that it is reasonable for them to become the tenant. Now, it's quite difficult to define what that might be in advance, and unfortunately there have been no cases in the land court which have looked at this issue since the new rules were introduced in 2016. It seems to me, however, that someone who doesn't have any previous connection with the farm at all, or any close relationship with the deceased tenant, might struggle to persuade the land court that it is reasonable for him or her to become the tenant. It's likely, of course, that that person's skills and experience, financial resources and character will all play a part in determining reasonableness. But I think there must be something more to being able to demonstrate reasonableness, because otherwise there would have been no reason to restrict the grounds of objection so far as near relatives are concerned to character, financial resources and skills and experience. So I suppose we'll have to wait and see until an inheritance is actually challenged in the land court to find out how the land court regards its role in assessing reasonableness or unreasonableness and what it's prepared to take into account. So watch this space. Turning now to look at intestate succession, this is the second route to becoming a tenant after the death of the previous tenant. Now, the procedures are set out in the Succession Scotland Act 1964, and they allow the executors of a deceased tenant to make a transfer of the tenant's interest in the lease to someone in satisfaction or part satisfaction of their right to share in the intestate estate of the deceased, or in satisfaction of a claim for prior rights or legal rights. Put very simply, when someone dies without a will, rules apply with regard to how their estate is to be distributed. Normally it's the spouses and then children and grandchildren. In the absence of surviving spouses, children and grandchildren, then it's possible for siblings to inherit. In the absence of surviving siblings but who have left children, it's then possible for cousins to inherit. However, even if there is no one at all within that category, The executors may also transfer the tenancy to any other person. Now that's extremely significant, because that other person would not appear to have to be a relative of any sort of the deceased tenant. So not a near relative or a relative in that wider category of people that I've already described. So that might not matter very much to a landlord with a fixed duration tenancy, because they're guaranteed to obtain vacant possession when the tenancy comes to an end, and all that a person who inherits such a tenancy inherits is the unexpired portion of the lease. That's not the case, however, in relation to a secure tenancy, and it raises the potential, at least, of that secure tenancy never ever coming to an end. In which case, the grounds of objection are going to become quite important. Where somebody has acquired a tenancy by virtue of a transfer by the executors as an item of intestate estate, if the person falls within the near relative category, then the objections are restricted to character, financial resources, and skills and experience. If, however, they don't fall within that near relative category, and might in fact be another person not related to the deceased tenant at all, then it's for that person to satisfy the land court that there is a reasonable ground for them to become the tenant. And therefore all of the potential arguments and considerations which I've already described in relation to testate succession would apply to a case of this nature. Now, it seems to me that this is a much more likely candidate for litigation in the land court in relation to a secure tenancy where the stakes are very high indeed. And I suppose it'll be very interesting to be involved in a case like that as a professional, albeit if you're landlord or tenant, it'll be a very expensive and stress-inducing experience. So, time limits. This is a subject which is hidebound by time limits, which are ignored at your peril. In relation to testate succession, the legatee, meaning the person who has been left a formal bequest of the tenant's interest in the tenancy, that person must give a notice to the landlord that they have accepted the bequest within 3 weeks of the tenant's death. There is provision for an application to the court on cause shown to extend the 3-week period, but the circumstances in which the court's likely to allow that to happen are extremely rare. And to all intents and purposes, if you miss the 3-week deadline, then the bequest cannot be accepted. Bear in mind also, of course, what I've already said about whether or not a lease can actually be capable of being made the subject of a bequest in the tenant's will or not. The time limit in relation to intestate succession is that the deceased's executors must obtain confirmation to the deceased's estate. That's the formal procedure by which an inventory of estate is lodged with the sheriff court, and the sheriff court grant authority to wind up the estate that is listed in the inventory, and the inventory must therefore include the tenant's interest in the lease. The executors must obtain confirmation, and then they must transfer the tenant's interest within 1 year of the tenant's death. On the transfer taking place, the acquirer must give a notice to the landlord that they have acquired the tenancy, and that's within 3 weeks of the transfer itself taking place. We had a recent experience in the office where another firm was dealing with the winding up of a deceased farmer's affairs, and about 3 weeks before the anniversary of her death, the family became aware that she'd actually been the tenant of glebe land from the Church of Scotland on a fully secure tenanted basis, which had been completely overlooked in the administration of the estate. Not the fault of the solicitors winding up the estate, it's simply that the family had completely overlooked it. The solicitors got in touch with ourselves because they lacked the necessary expertise, so we had a 3-week period of time within which to add the tenant's interest in the glebe land to the confirmation, which involves a separate application to the Sheriff Court, and then persuade the Sheriff Clerk to process the application quickly enough so that we then had confirmation to form the basis of a transfer to, in this case, the tenant's grandson, and then a notice was given within the 3 weeks of the transfer. The consequences of missing those time limits would have been that the tenancy was lost, so that if no formal steps are taken to confirm to the deceased estate, including the deceased's interest as tenant, and no steps are taken then to transfer that interest to a suitable family member or other person within a year of the death, and if the transfer having taken place, the acquirer doesn't give notice to the landlord within 3 weeks, the tenancy lapses and comes to an end. So, moving on to objections. Once again, they are subject to time limits. A landlord must make an objection within 1 month of receiving a notice that the tenancy has been inherited, whether it's been inherited by testate transfer or intestate transfer. The landlord must specify the nature of the objection in the notice. If a successor receives an objection from the landlord, they must make an application to the Scottish Land Court to overturn the objection within 1 month of receipt of the objection. If the landlord misses the 1 month time limit for making the objection, the landlord loses the right to object and the transfer isn't capable of being challenged. If the successor tenant receiving an objection doesn't make an application to the Land Court within a month of receiving the objection will be valid and the tenancy will come to an end as a result. A bit of a war story about that. I was recently involved in a case, too late to be able to do any good unfortunately, but the tenant in a secure agricultural tenancy left a will, and in the will he provided that he left his interest as tenant in the farm to his son. Now both the tenant and unfortunately the solicitor drawing up the will were ignorant of the fact that the lease contained a prohibition against assignation and therefore the bequest was invalid. Tenant died and the son was made aware of the contents of the will and served a notice within 3 weeks on the landlord that he was accepting the bequest and that therefore he was now the tenant. Landlord received the notice, didn't acknowledge it and simply sat back and did nothing further. The May and November rent terms came and went without the landlord issuing a rental invoice on either occasion, and it didn't occur to the son that he should volunteer to pay rent on his own initiative. A year from the original tenant's death elapsed, and in the week following, the landlord solicitors wrote to the son to explain that the notice that he'd served that he was accepting the bequest was invalid because the lease did not allow a bequest to be made, and the landlord solicitors noted that they hadn't received any notice that his father's executors had confirmed to the lease and transferred the lease to him. The year's time limit within to do so had lapsed, therefore the lease has come to an end and please could he give up vacant possession of the farm. And there was no way back from that, unfortunately, although I suspect that the solicitor who drew up the will probably had to dust down their professional indemnity policy. So, problems and pitfalls. Watch out for joint tenancies. Where a tenancy is held by joint tenants, unless there is a specific clause in the lease providing that the tenancy is to the tenants jointly and to the survivor of them, in which case, if one of the joint tenants dies, their interest as joint tenant passes automatically without any process of law to the surviving tenant. If there is no such clause in the lease, and one of the joint tenant dies, that interest as joint tenant must be transferred to a suitable person, because if it's not, the tenancy will lapse. And the joint interest is subject to the same procedures that I've already described for testate and intestate succession. There was an estate in Angus who had a habit of granting tenancies in favour of parent and child without any survivorship clause, and at least 2 of those tenancies were lost about 20 years ago because the joint interest wasn't transferred on when the parent joint tenant died, with fairly dreadful consequences. That was at a time when these rules weren't perhaps as well understood within the profession as they should be, but for goodness sake, watch out for that. Check the up-to-date identity of the landlord. There is a rule that an existing tenant is entitled to regard the original landlord as his or her continuing landlord unless they receive a formal notice to the contrary. No such rule exists to protect an inheriting tenant. So if someone inherits a tenancy and serves what they think is the appropriate notice on the landlord, but the identity of the landlord has changed in the meantime, the notice that they serve will be invalid, and that can lead to the end of the tenancy. Another pitfall I commonly come across is where the tenant is a partnership. It's not possible to inherit a partnership's interest as tenant, and unless the lease makes very specific wording to the effect that the lease is granted in favour of the partnership, regardless of who the partners might be from time to time, the death of a partner will be an event which terminates the lease, and there's really not very much can be done about that. Always make sure that you understand what lease governs the tenancy. It's often the case that the family think that the tenancy is governed by a lease which might have been granted 30, 40, 50, 60 years and longer ago. But actually, when you examine the circumstances, you discover that there was a death at some stage during those years where no proper procedures were followed to transfer the tenancy, and in fact what we're dealing with is a tenancy which arises because of operation in law, and there's nothing at all in writing about that. So I've fairly rattled through that, although I think I'm on time for my 30 minutes. I hope that as a result of that you have a clearer understanding of some of the issues in relation to succession to agricultural tenancies. Having a look at attendee questions. Nobody submitted a question, in which case either nobody is listening or in fact I've been much clearer than I thought I was. As I said at the outset, very happy to pick up with people after the webinar should they have any individual questions themselves. But otherwise, I hope that you enjoyed this latest webinar in the series being hosted by the Rural Disputes Resolution team at Shepherd and Wedderburn. Goodbye.